All right, now call to, wait. There we go. All right, I now call to order this special meeting of the City Council of the Village of the Hills. Today is March 26, 2026. It is 9:01 a.m. Thank you for joining us. Please rise and join me in honoring our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, public comment period. Members of the public may address the city council during the public comment period on items which may or may not be on the agenda. Speakers must address all comments and questions to the presiding officer and must limit their comments to 3 minutes. Inquiries from speakers about matters not listed on the agenda will either be directed to staff or placed on a future agenda for council consideration. Sir, do you have any public comment at this point?
Okay. But I just want to thank y'all for everything y'all do. It's an act of service, and appreciate all your help at this point.
Thank you. All right, hearing no other public comments, public comment period has now ended. Items 4, business items. Council will individually consider and possibly take action on any of the all following items. A, discuss and consider action to recommend proposed amendments regarding section 9.04.205 permissible and conditional uses in zoning districts of the city zoning ordinance regarding accessory dwelling units, and proposed amendment to section 9.04.404 regarding approval of zoning verification certificate applications. Josh, you want to go ahead?
Yeah, so I'll set this up. So essentially there's a conflict between in the ordinance, right? And so part of the ordinance says that if the Architectural Review Committee, that's the name, if it approves an application, then the city council has to approve, the city has to approve that issue a zoning verification certificate for that, right? And somehow when we were drafting this, I think there was a disconnect between me and Lee on the final draft. But the problem is that the rest of the city code doesn't actually allow that use as a land use in single family districts. And so we were presented with a situation where the POA had approved, as I understand it, an accessory dwelling unit, but it was after the code had already been adopted. And so if it were, the zoning code doesn't affect any accessory dwelling units that have already been approved right before the code comes into effect. Those are what were called grandfathered. They have vested rights. But when we looked into this particular application, it appeared that it had started after the city's code was already adopted. And so we had this situation where the code doesn't allow for this land use after the code. And, but the code also said that we had to, or the council had to, or the city had to issue a verification certificate. And so I informed Angie that, we could not honor that application because of the way the code was written. And so I requested, to fix that, we need to, bring this issue back, get direction from y'all in terms of if you intend to not allow any accessory dwellings or accessory dwelling units, or you do want to allow them as conditional use. That is that if the Architectural Review Committee, approved it and they met all those things, that y'all could bring it back and do it on a case-by-case basis, right? But it has to also be, it can't be arbitrary and capricious, right? So we need to have standards for when those are approved. And you can adopt the standards from the Architectural Review Committee. We just didn't do that. So if that's what y'all want to do, and you want to say, if the Architectural Review Committee approves any accessory dwelling unit, then, we will do that. But I still think it needs to come back, and, you guys need to be able to say, yes, we agree that it meets our comp plan, and that it, meets the standards that we've set out for accessory dwelling units. But again, we need to come up with, non-arbitrary standards for when you're going to allow them, right? And you can put conditions on it. I have some cities that will say, they'll be approved, but they have to be on, they can't be, can't be separately metered. They need to really be, if we're going to allow them, then they really need to be used by the same family, right? It's for single family use. And you guys already have short-term rental ordinance that would not allow that anyway, I think, right? So I went through and quickly sort of noted where I thought we would need to change, if that's something. Again, I'm asking for direction. I mean, some of this is policy, right? So if you want to move that direction, I've made some suggested changes that we need, that I would add. And then I guess at this point we can, if you have any legal questions, we could go into executive session and we could talk about some of those, and then, I'll come back out and just, discuss the pros and cons of the policies.
Are you our POA liaison? You are?
Unfortunately, we have an expert here on the
I
POA.
know.
Expert is probably.
So they have the architectural committee has a pretty comprehensive plan of approval for ADUs. Like I have a second lot. So if I wanted to build an ADU and have it connecting whatever, like, are there limits on how big it can be?
So the architecture rule book is completely silent on secondary structures that are enclosed.
Oh,
Yes, which has been a problem, and the architecture committee is in the process of defining this language. They have gazebos, they have outdoor kitchens, they have structures that are not enclosed. So there have been 4, maybe 5 that have been approved over the years.
okay.
And it's kind of up to the architecture committee at that time for the respective 4 or 5 that have been built to approve them or not. During my term, there was one that was approved by the architecture committee, unbeknownst by the board, which is typical, right? The board doesn't go through all the architecture approvals. When another one came through that was on an amended double lot from Mr. Young, that's when it started getting like, where do we have this in the architecture rule book so that we can make sure that we're not, is there impervious cover? Is there a lot size restriction or requirement minimum? So the architecture committee is in process of updating the rule book to be specific on that.
Got it. Okay. Right now, TBD. Got it.
Correct.
Thank you.
It does have diligence through the architecture committee to approve them, but it's whoever's on the committee at the time, it's kind of up to them to.
Right. There's nothing that's been immoral.
Yes.
Okay, so when I hear you say that, it sounds like we cannot adopt their standards because they have no standards right now, right?
That's what I'm thinking. So we have to.
But it seems like there also should be some,
I don't think we should.
that should not be conflicting either.
And I feel like they're not the experts, but that is their wheelhouse, right? Architectural committee defining those.
Yeah, and that was something that the city council, when the zoning ordinance was adopted, my vote was a yes, because I didn't want to have to take on all of those responsibilities that the architecture committee already does. We don't have the resources in the office to do as much as the great POA does.
Makes sense.
But definitely want to make sure. My question to you, Josh, is these drafts, are these all new edits that we're seeing in front of us?
So I took the last Word version of the ordinance that I had and which I don't think changed much really from what was adopted. But yeah, I'm not saying that all of these, my recent edits should be shown, the red lines. And I'm just assuming that the rest of the ordinance is what was passed. But if we did an amendment, we would just amend the pieces that are shown as redlined and leave the rest.
So given what we've just recently learned about the POA, do we need additional, I guess, specs or regulation for the bulleted items that you have listed out under FYI.
So on the,
The page you had.
I'm on page 4. An accessory dwelling unit shall,
yeah, and these were just sort of starting points, right?
is it also in a comprehensive version or are we,
Well, these don't actually have any standards, right? I'd assumed that there was, or I understood that there was more on the POA side for these. But I think we could, if you guys want to defer to those when they're adopted, we should just explicitly say that and say that, you know, that the Architectural Review Committee, you know, must address, you know, whatever issues that would be related to your zoning authority, right? So they can, you know, they have to address, you know, square footage or density or, you know, those types of things that are within your zoning authority. And then if they meet all those things, you guys would defer to them when they're adopted. I mean, you can adopt their standards, but it doesn't sound like there's standards right now to adopt.
So what happens in the event? So the POA is in the process of setting, you know, these standards, defining what an ADU is and codifying all of that. It's in process though. Like, what if that doesn't happen?
Well, I would say from a city zoning perspective, it sounds like it's been pretty arbitrary at the POA up until now, right? And more discretion than standards, right? Which might be okay for the POA, but that's not going to check the box for what city's zoning authority is. It needs to be a little bit more defined. So
Okay.
once they do have those standards, we could, you know, y'all can adopt those. But, you know, we just need to make sure that there's no conflict. And then they can have something that's more stringent than what y'all have, right? Like if y'all don't care about, I mean, you can say that they have to follow the design standards, right? But those are really pluses, nices to have versus needs to have for y'all.
So is there a reference in these documents now to the POA architectural book?
So it doesn't, I don't read this to allow ADUs, but the one thing that it does have that I think causes the conflict is on page 13. So the current language says, if the owner has received approval of the project from the Architectural Review Committee of the Hills of Lakeway POA, then the city administrator shall approve the application and issue a zoning verification certificate, right? So the problem is, even if the POA approved the ADU, the code doesn't allow for ADUs currently. And so, and what I think was supposed to be is what I wrote up there, that if the owner's received approval from the Architectural Review Committee and the application,
This doesn't make sense.
yeah, is
wait. So
approved or something, or is,
owner. All right, so I apologize. It doesn't look like my edit actually made it in there. So it's supposed to say, if we receive an application and it meets the code and it has a conditional, it meets the conditional use requirements, then we'll issue it. And that's the piece that's, that I think is missing. And so we added because it has all of these, it has all the rest of the document has all the standards for how you would evaluate a conditional use permit, which is all correct, right? We're just missing that step. So we can't issue something saying that the use meets the code. The code doesn't allow for that use. So that's what we need to correct if you guys want to go that direction.
Code doesn't allow for the use because of what's on page 9.
Yes, because it just says one single family dwelling. And then the definition of building removes. But it looks like at one time we had ancillary structure there under the conditional use. And it was taken out by the final.
so my understanding, the way that it's drafted right now, and it would be a conditional use, so it would still come to council as the zoning commission to be approved.
If these red lines are accepted.
Right, if we're approving this document.
And again, y'all are not approving anything tonight or today. You're just
That's
giving,
right, yeah.
you're just giving direction on policy, what you want to see and concerns that you have, and then we can circulate.
Who was on so Sarah and I, Marty, were you on the council yet for the zoning approval?
Yeah.
Mhm.
Do you have any perspective? I know from my perspective,
What's
it's
been
been-
said, yeah, I mean, we can defer it, until they do have standards. That'd be good, but if we can't defer, then I'm not sure I don't think we should be defining the standards.
Yeah, so I think, so from my perspective, when we adopted the zoning, it was to protect the character of the neighborhood, specifically the commercial, open space, recreational, and community purpose areas for very specific reasons, around just preserving those as they are. My intention when I voted was not to take on any administrative burden, especially for our one employee, Angie, who does a very good job, to be approving these specifics of the roles and responsibilities that I believe the POA currently possesses, because I think then it would be, my perspective should be an all or as minimally administrative as possible. So I would prefer to have the POA be the ones in the community as it is now that regulate the building standards. My intention when we drafted was that as it's written, but not clearly, if the POA were to approve any permitting, that we would, within the zoning and our intention of protecting the zoning district, single family, residential, multifamily, commercial, open space, recreational, community purpose, that we would then go along with the POA's standards and approve them. But it sounds as though now we have a change here, but my intention would still be to, if we can do it, adopt their standards, which they don't have standards, but I don't want to be the one that's regulated. I don't think the city as a structure now should be the ones regulating the standards for those accessory dwelling units. My intention is to keep single family, residential, multifamily, commercial, open space, and recreational community purpose as they are now, and allowing the POA to determine within those parameters what's appropriate.
I would agree. I also think the added language on page 4 around ADU definition protects the city for the city needs protection, right, in terms of this electrical meter. It prevents somebody from putting 4 tiny homes on their lot and or terminals aside, but even if you say I've got a tiny home in my backyard, I'm going to rent it out on an annual basis, right? This protects us in that realm.
Okay.
I can put a tiny home in my backyard.
I'm saying if somebody does, right?
Okay,
Sounds like you have a little bit of time.
Sounds like I do.
I don't know.
I'm not advocating for that. What I'm saying though, as a.
Just make it through the people of the AC right now.
If there's.
Yeah.
I mean, it's 5 volunteers on the architecture
Right.
Yeah.
committee. If those people, and, not to speak out of turn, but if the architecture committee approves something, the board cannot overturn. an approval.
Oh, so I know, so that's where my concern right now is like impervious cover. You brought that up, and I think that is a challenge in protecting our city and like the green spaces. I would hate to see some developer come in and buy something like, a double lot and take over all the space and take out all the trees and stuff. So that's where, when I asked about how comprehensive our ADU the kind of the list, I do wonder if there should be some format of a standard there in place until the POA gets more detailed standards written up.
you're thinking we need to firm this up.
So are you thinking square footage or? I don't know that we have.
But just for this, but then just with the intention of repealing it once they have their own,
Yeah, with just a,
what's the timeline you think for them to codify it?
Supposed to be done before.
That's, I mean, I'm not saying I don't have.
But-
full time, yeah,
There's a,
Yeah.
there's a,
it's years.
it'll be within a quarter.
Okay,
I can't speak for them, but they have a new chair now. They filled all the seats as of last month, so fresh eyes and more rigor,
Is there anybody applying right now for permits for any of you?
not that I'm aware of.
So it might be able to play it.
I mean, it's a pretty rare circumstance, right? Unless somebody
Right.
throws something in a tiny home, but it's really uncommon.
Yeah.
Most people that are, like, there's protections in there. People can't put greenhouses in, and even if somebody tries to put a tiny home in, because there have been requests in, especially around COVID,
Mhm.
people put in small buildings for offices, and those have all been appropriately rejected because it's
Temporary.
If I recall, the architecture standards weren't equivalent to the home standards. Has to be pretty equivalent.
I mean, the architecture committee, from what I've seen in my experience, they do a great job of making sure that there's consistency.
Mhm.
Maintain the integrity of the neighborhood, where people can't just put in random greenhouses or even playscapes and stuff.
Do you mind? Because we as residents, we don't vote on the people serving on the architecture committee. How are those people brought
Be
in,
appointed by the
appointed by the board? Okay,
who are elected.
okay, great,
They work in.
okay.
So I want to go back just a second to the language that what we propose, and I don't know what,
For 13 patients.
Like conditions. It's just we don't have the standards in by which
yeah, so on page
we
13,
don't have
what,
it, and deny it for a reason.
It makes us simple.
what we said was if the owners received approval for the project and the application demonstrates compliance with all city zoning requirements, no conditional use approval is required, then the city just issues a zoning verification, right? So, and then we made it a conditional use for the ADUs. And so what we really did was just put a speed bump in there to say, hey, if it does require a conditional use, then that needs to just
Yeah.
have a check-in with council before that final ADU is approved, if that's what you want to do. And if you wanted to not have that speed bump there, then, we can change the wording, just to say, I mean, if you want the POA to be the final say, then we still need to change the zoning ordinance to say that we will allow, on single-family lots, we will allow the single-family residence plus an approved ADU by the POA.
So for the speed bump, so what would be the practical implications of the speed bump in terms of like process and?
I mean, we don't have to have it, come back here. I mean, we could just say that it just, there needs to be an administrative review, that it actually meets whatever the requirements are. Because right now, it really makes it mandatory. And that's the piece that I had a problem with, because right now it says if the Architectural Review Committee approves it, then the city must issue a letter saying that it complies with the city's zoning code, right? And that's just not true because the city's code doesn't allow it currently.
Okay.
Well, I would think that the speed bump would be appropriate to make sure that it's aligning with page 4,
Yeah.
where we have there, and then also for property tax implications too, right? What we heard from
Chief appraiser.
thank you,
Mhm.
last month.
I was gonna say tax.
If there's an additional home there, if it's being used for that single family, or if it's being used for renting separately.
Yeah, I mean, ideally, they should probably file the applications with both entities at the same time, right? So that any city concerns can be addressed. I mean, we could draft this so that, it's administratively approved for the special condition, and, it can be administratively approved, or it can be sent back to the POA to deal with any issues. But again, I think timing wise, they should apply at the same time.
I like the speed bump. I don't like the idea of it being kind of subjective to the board. So if it's then just going back to 4 as the compliance or page 4, then I think we should just think through that a little bit more. But I don't think it should be like subjective to our whims.
No, I agree.
Yeah, it would have to always come back to
have
this.
standards.
Yeah.
And then so on that, the one thing that concerns me is the separate meter. I think good idea and well-intentioned, but then it concerns me that that's a disqualifier because it may not be the property owner's choice. Could be the utility
Yeah,
company
could
that
be.
says, no, you have to separately
Yeah.
meter this, even though you're still using it for your family.
Well, I mean, and part of our application could be that your application states to the city that you are using it as single family use, right? And that way you're complying with the short-term rental requirements as well.
What happens if do we just fine them then? If they just go against, if they end up renting it to somebody?
Yeah, I mean, it would be a violation of the city's ordinance, right? Typically, the test usually for zoning cases is that, and they don't even have to be, you need to be living as a family unit, right? So it's not necessarily blood. It can be in-laws. It can be adult children.
Yeah, I think that's
whatever.
completely
So,
reasonable. I think that's completely reasonable. I think in the spirit of,
But,
Yeah, it brings,
I think what we're looking for is permanency and then for there not to be like a financial arrangement. I think that's really the litmus
Mhm.
test of
Yeah.
a rental.
yes. And so right now.
well, I mean,
That said, if you have an adult child.
if you have an adult kid, you can rent, I don't have an issue with somebody having an adult kid and rent, like,
Charging them.
there's like
Yeah, yeah.
20-year-olds that pay rent to their parents. I don't have an
I get that.
issue.
well, it's not, in that case, it's still not really paying rent.
Yeah.
It's more of a family unit contribution, right?
Yeah.
They're sharing in the household expenses.
Yeah.
Is how I would say that, but,
They're not writing up the lease probably for their kid.
um,
I mean, even
So
if
that
they
brings
were
up
to,
the
though,
question.
I
So like we have properties that the POA does allow to be leased and rented out greater than 30 days. Okay, so are we going about an assumption? So if somebody builds an ADU, would the POA then, or would we have to have a rule that doesn't allow them to rent that out longer than the 30 days? Because we don't have anything.
but we do prohibit, we have an
She means long.
I'm talking long-term, like if you had,
long-term, we can't really regulate.
can't regulate that.
We cannot regulate if somebody has an ADU and they rent it out to a non-family member.
No, we can do that because
Oh, okay.
that's not
Yeah.
single.
Okay.
That's what I'm
not
asking.
single
Yeah,
family.
Thanks
that's
for
what you're asking,
clarifying. Yeah, you
Yeah,
got
so
it.
it goes back to single family.
Okay,
I'm just saying that single family is not just, it has a broader
Broad definition.
definition.
I think we're all comfortable
Okay.
with that definition.
okay, thank you for
So we're not allowing
clarifying that.
more than a single family.
Okay.
We're just saying that, so like I said, the main thing is we need to change the definition and say that we'll allow a ADU
Hmm.
to be single family use, but it still has to be single family use.
Gotcha.
I'm fine with this. I think a speed bump, given the low volume
Mhm.
of requests for ADUs is appropriate. I do think we have a timing, because I know from my understanding, there is an open request. So how do we address that open request now? Because this is going to be, and obviously we should do all this appropriately, but just for reference, I think we have to do a hearing
Mhm.
that has to be noticed 14 days ahead, or what is it, 15 days ahead, and then a public hearing and a meeting to approve any changes to an ordinance itself.
Mhm.
My intention, I don't know. I was hoping that we could have a speed bump. My big concern just with the zoning is just making sure that we protect the integrity of our zoning classifications and districts. and making sure those are never, well, my intention would be those would not change. And then if the intention was that the POA approve something, we would approve it based on whatever standards that they have. So I think, so I mean, Marty, what was your suggestion? Just making sure we have parameters on page 4 that sufficiently address our concerns as a speed bump, and then approve, and then having, and Josh, you said we could have an administrative approval, like and just approve it?
Well,
Or,
Under conditional?
I mean, most cities do conditional use ordinances. I mean, we could still. I need to double check that, because if we have to do an ordinance approving it, we might have to do a public hearing at the time.
yeah, I mean, give it, I was just wondering, I don't mind having to come back here and like approve, given the low volume.
Do you think there's low volume because it's kind of implicit that they're not approved? Or like, do you think that the volume will increase by us defining it now?
I mean, the architectural committee would still have to approve them. Maybe that may be the volume of applications.
I mean,
I think if you give
my
a volume
tiny house
application, I'm
is
sure like
applications,
theoretically, like if people now, I mean, it's a public meeting, I assume people would
yeah, I mean, that's.
be like, oh, I
wondering-
can do so-and-so, but it's gonna go to the architectural committee,
Okay, got it.
which again, like I think we should either regulate everything, be the ones that regulate it, or let the ones that are currently regulating it continue to regulate. That's my perspective. I mean, that's my personal policy perspective. We can all debate that.
Well, I mean, look, density is one of the things that it's a clear zoning issue, right? So, I think you do need to think about, do you want to allow every house to have an accessory dwelling unit, what that size is, or all the lots the same sizes here?
Yeah, but even if we were,
That's where it's.
and this, I mean, even if we were to allow all of them, the POA would still be determining whether they would allow it. So if there's like, so anywhere that's currently regulated by the POA and AMD, all the single family and multifamily would be still regulated by the POA and constrained by the POA's rule. Anything else that's on our, so somebody, for example, buys the golf course and wants to develop the golf course, that's already prohibited regardless. So I think we would be protected based on those zoning districts against that's adverse decisions.
Do you want to,
So I think my perspective on the POA is more restrictive than it limits it. I think my perspective is the current stopgap issue, or if the architectural committee were to do something extreme with their standards and all of a sudden enable everything. But then in that case,
so can we maybe go into executive session for a few minutes?
Yeah.
yes,
And let me give you some advice.
yeah, we can do that.
Would read us in, maybe. And then we can come back out.
Question. Is there a time for me to speak again, or is that done, that item that went by?
I mean, technically, you can come back and he can recall the
Okay.
item and you can give some public.
Can I just am I allowed
let
to
him do it
get,
now.
I can, that's my discretion. I can, you
Well,
can,
just, because I'm not sure.
yeah, keep that open and you can, I'll let Kevin Young give an additional public comment.
So just, I'm not sure how familiar everybody is with what went down, but we found this is really a double lot. You're talking about density. You can't build an ADU on a 1/4 acre lot. That's typically what these things are. We have 2, it's 0.4 together. Would have been a house there anyway, as far as density goes. But as far as the timing goes, we bought this house on the basis that we could build a dwelling unit. My mother-in-law sold her $450,000 house in San Antonio. We got the POA. It was a conditional approval, but with conditions of, hey, we've got questions. There's a couple things we talked about just design wise that we ironed out. But that was in October. And from what I understand, this ordinance was adopted December 1st, somewhere.
October 14th.
Oh, it was October 14th. So it was pretty much right on top of each other. And I guess, lesson learned. I guess I'll never probably have the chance to apply this lesson learned again. But I should have required, we rented the house until the approval. But we were told, different things about the process, that it's POA and then it goes to the village and then it goes to the MUD to get some stuff in. Anyway, we got the approval. I can't remember when it was in October. But all this was obviously going on for months. Y'all were talking about this ordinance for a long time.
Correct.
So we bought the house with the understanding that this was allowed. It's a beautiful project, honestly. We don't have any intentions of renting it out. I understand the concern. Y'all already have a rule against it. I just didn't know if everybody knew that we bought this on the base, on the condition that, hey, we can build this, this dwelling unit for my mother-in-law to live out her final years. We're 20,000 in, on design, and just engineering and architecture. Anyway, I think something could be worked out. I don't know. Maybe it sounds like maybe it's going that way. I don't know, but, we have been waiting a long time, and she's in our guest room suffering with 11-year-old, 8-year-old boys running around the house. Bless her heart. But anyway, if I would hope there's a way to look at this and say, wow, these guys kind of got screwed a little bit by a process that maybe wasn't in place, or maybe there was an understanding. Everybody misunderstood each other. The POA, the village, no one was talking to each other. The MUD. I've driven around and seen a lot of beautiful double lots with additional dwelling units on them. There's a lot more than 5. There's a bunch of them. And so anyway, this is a situation we're in, and it's very, 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 very unfortunate because we could have gone elsewhere. I'm glad we didn't. We love this neighborhood. We've made somewhat of a splash as new neighbors. But anyway, I just wanted to go through that because I'm not sure, everybody was.
All right. Yeah, well, thank you, Kevin.
I don't have the context, but so you're in a house on one lot, next door, you own the other lot that's empty?
It's behind us. It's platted as one lot. So they whoever it was once upon a time made it one lot. So it's replatted.
Right.
But that lot is where we're building the house. And it's got a pool, all the backyard is there basically. But it's a 1,400 square foot pad, 1,000 living square foot, matches the house, all that good stuff. So anyway, it's a curveball. It's scary because we bought $1.5 million house on the basis that we could do this. So, and apparently a lot of things were going on at the same time. I wish we would have had the foresight to also look into, what the village would allow, but we weren't privy to that. We thought the POA had the authority just based on the research that we had done for 6 months leading up to, buying the house. So anyway.
All right. Well, thank you, sir. Appreciate it.
Thank you.
Okay. Now,
Right, yeah,
go back.
go ahead.
I guess I got to open the door again too. Gotta open this just to convene it. Okay. The mayor executive session, the mayor and city council may adjourn into executive session at any time during the course of this meeting to discuss any matters listed on the agenda as authorized by the Texas Government Code, including but not limited to section 551.071, consultation with an attorney, 5A, Texas Government Code, Section 551.071, consultation with attorney regarding legal interpretation of city's zoning ordinance and legal recommendations, if any, for amendments to the city zoning ordinance. It is now 9:40. We are convening into 9:41. We are convening into executive session.